I'm going to give you a little bit different perspective on all this. And to some extent, I'm going to challenge this idea of entitlement to confirmation. But the way I want to do that is to look at this more historically, and two overarching points that I want to make. And I'm just going to give you in folksy terms, but straight at the top, which are, one, the U.S. system's unique. And second, confirmation problems shouldn't come as a big surprise. So let me explain this. One thing you have to remember is that the United States was founded in the 18th century. And if you think about the dominant form of government in the 18th century, it was monarchy. And you had a king in England. At the time, you still had a king in France. Throughout most of Europe, you had monarchies. At one point, at least, not necessarily at that time completely, there was this notion of divine right, that the kings were the representatives of God on earth. They were carrying out God's will. And what we saw was, through the Enlightenment, there was a challenge to many of these concepts and the articulation of a new and fundamentally different approach to government. And we get two basic ideas. One, the notion of rights. Think about it. If the monarch, to the extent that anyone ever accepted the notion of divine right, if the monarch was God's representative on earth, well, we're not so sure that ordinary people have rights, much less the right to criticize the government, which is part of the reason why when Gutenberg developed the printing press in the 15th century, the English responded by creating this crime of seditious libel, which made it a crime to criticize the government. And, well, if you really believe in divine right, it makes sense. Why would we let ordinary people criticize what God's representative is doing? Now, when we get to the Declaration of Independence, we see the adoption of the views of writers like Locke and Paine and Montesquieu. You see elements of natural law where they're saying essentially people have certain inalienable rights. We also see the notion of democracy. The notion that the power to govern stems from the consent of the governed. And these were remarkable ideas in terms of being adopted into a governmental document. Particularly remarkable because in order to succeed in revolting against England, we needed the help of France. And France had a king at the time. And he kind of overlooked these revolutionary ideas and decided to help us anyway. And not knowing that a few years later, in 1789, France was going to have its own revolution, and it's going to result in its beheading, in his beheading. Which is interesting because Louisville, where I live, actually is named, it comes from the French king. And everybody assumes, and I assumed until some years ago, that it was for Louis XIV because he was the grandson king. And I found out later that it was actually named for Louis XVI, the king who was beheaded in the French Revolution. So interestingly enough, we're probably the only city in the world that has a statue of Louis XVI. Now, all that aside, we have this notion of democracy. We have this notion of certain inalienable rights. But the other funny thing was, neither the framers of the Constitution nor the people of the United States were very trusting of government. In other words, we have this notion of democracy, but they're looking for ways to control it. We see it it's most evident in the fact that the framers in the Constitution itself adopt Montesquieu's ideas from The Spirit of Laws, his idea of checks and balances. In other words, we're fearful if one branch of government, if we have a king who holds legislative, executive, judicial power, and so the idea is split it up between the various branches of government. And that's exactly what they did. Now, this is just a small aside. As distrustful as the framers were, they weren't as distrustful as the American people were. Because after they created this proposed Constitution and sent it to the states for ratification, the people said, wait a minute. A number of states said, wait a minute, there's no Bill of Rights here. And we need specific protections against the government. And ultimately, that's how the Bill of Rights came into the Constitution as an amendment. Now, when we think about the Advice and Consent Clause, there was a lot of debate at the convention about how this should be phrased. In other words, should we just give the president the right to make the appointments? Should judges be appointed by some other body? Finally, they adopted the notion of advice and consent with the notion that the president would be checked by the Senate, which would have the right to say, no, this is not okay. We're not comfortable with this particular person. So when I hear arguments that the president's entitled to this or entitled to that because he won the election, well, I mean, when I look at Obama, you know, it's interesting. Obama won by less than 4 percentage points in the popular vote, besides which the Constitution makes it quite clear that there is to be advice and consent. So it specifically accepts the idea that there could be a divergence between the president and on the one hand and the Senate on the other hand. And in fact, if I were going to make an argument, I would argue that I think in general, the United States people tend to like divided government. Because when you get a more active president, Republican or Democrat, who has Congress, or particularly when they have both houses of Congress, what we find typically is that people say, well, maybe we'll shift one of those houses of Congress to the other party. So it's a way of checking that authority. So to me, it doesn't come as a huge surprise that we have confirmation battles. And the other thing I'd suggest is that these confirmation battles have existed throughout the history of the United States. Even President Washington had trouble getting justices confirmed to the U.S. Supreme Court. Throughout the 19th century, we have instances where presidents have had trouble getting individuals confirmed to the U.S. Supreme Court. Now, in general, the judiciary is different than the executive branch, and that's an area where I can make a stronger argument for you should be more deferential. But, and so if you look at the history of confirmations, what we find is that by and large, the Senate has been more deferential in terms of presidential confirmations. Now, I think we're looking at quite a different scenario now. Quite different because, one, there's the level of partisanship is quite high right now. And if you ask me what's going to happen in the next 2 years, I would expect that Obama's going to have a lot of trouble with confirmations. And I think I can make an argument that that's a quite healthy process. You're going to hear arguments this afternoon about formalism in interpretation versus more pragmatic or functional approaches to interpretation. But I think the notion of Senate blockage plays an important role. Obama has certainly staked out positions. I'm entitled to do this. We see it with immigration. We've seen it with a whole series of things. And if you've got a president who chooses not to cooperate with Congress and to simply say, I'm going to go my own way and heck with you, well, you get pushback in lots of ways. And I think one of the ways you get pushback is in terms of refusal to confirm the appointments that they want to confirm. In other words, I think it's part of the checks and balances, and it's part of the way the Senate says, if you're going to go your own way, fine. You want war, you got it. And Obama, since the recent elections, has made it more than clear that he's not all that interested in cooperating with the Senate or the Congress. And so none of this surprises me to some extent. I think it's healthy. In other words, I don't like the talk of, oh, well, we should have a more functional approach, because what are you doing? You're gutting the idea of separation of powers. You're gutting the idea of checks and balances. And I think it's quite appropriate if there are policy odds to say, no, this really isn't acceptable. We're entitled to stake out our own positions, and if you want to go your own way, there are going to be consequences to that. And I think that's just part of our own system. Now, if you want to contrast to the American system, look at the English system. Very different system. You have a token monarch. I mean, you know, she can't even give her own speeches. Generally, only one day a year that she's even allowed to give her own speech. You know, so she's just a figurehead. The prime minister controls the government, but the prime minister becomes the head of government because either through his party or through a coalition holds a majority in Parliament. In other words, you have this combination of executive and legislative functions. So, of course, if the prime minister wants to put somebody in a position, unless it violates one of the British customs, then he has the right to put that person in the position. And we could have gone in that direction if we wanted to, but it's a very different form of government. It's not the government that the framers of the U.S. Constitution chose to adopt, and we chose a completely different course. Now, it's probably, as I said, directly related to our history. It's directly related to the notion that of when we were created. It's directly related to the concerns. And it's directly related to the notion of trying to control government. You have a situation where we had just revolted against England to claim our independence. And also, you have a lot of people who immigrated to the United States in order to escape religious persecution in Europe. And so there are a lot of reasons why there was this distrust. And it plays out in terms of checks and balances, separation of powers. And the advice and consent clause is simply one other reflection of how it plays out. Thank you.
And now we'll have some additional commentary from Professor Friedland, who's joining us from Emory Law School. Oh, Elon, sorry. Wow. Elon. I'm like...
Good afternoon. I first would like to thank Brett and Bill and the rest of the Law Review for inviting me and for putting on this really terrific forum so far. Russ Weaver, who I've known a long time, provided, I think, a good historical outline of what happened with the Appointments Clause. He tends to be contrarian, where he actually likes the conflagration that occurs with the nomination controversies. I'm a longtime New York Mets fan, and I tend to be contrarian as well. So I agree with him to some extent, but I will agree with his history, but not the way he interprets it. So my major point is going to be this. Essentially, the Appointments Clause was a brilliant masterstroke of judicial and other really not judicial, of government interdependence. But I think the danger from Senate deference is just as great as the danger of obstruction politics, the political polarization that we see now. So, let me talk a bit about this brilliance of the Appointments Clause historically. And interestingly, I don't think you can find the brilliance in the Constitutional Convention from the framers. It was initially proposed in the convention that the clause would be, or I should say appointments, would start with the national legislature, and they would appoint the national judiciary. And I'm, again, focusing here on at least judicial appointments. From that starting point, they ended up with lots of different permutations. And they also had the legislature proposing, the Senate proposing, the president nominating, the Senate with the approval of the president with the approval of 1/3 of the Senate. They went back and forth, and the Appointments Clause ended up in the Committee on Postponed Matters. This was one of those which interestingly mirrors exactly what's occurring. In other words, we talk about postponement. This was not adopted until September, towards the end, when they all threw up their hands and said, let's just get something passed. And even the major framers flip-flopped a little bit in their positions just to get this through. So what do we get from this? It's a compromise. It was adopted as a great compromise, and I think that's part of the brilliance. Now, interestingly, who was cabined? Really no one. The president nominates, and then the Senate has advice and consent. When you look back in history, what's to stop the president's discretion? Now, Jimmy Carter created nominating commissions. He wanted to restrain his own discretion, I guess. And of course, for Carter, the only full-term president who didn't get to nominate a Supreme Court, he didn't have a Supreme Court nominee, that was an interesting sidelight for him. But the president does not, in this, have any limitations on discretion. And the same for the Senate in the way it was enacted. Russ talks about the beauty of how this was forged because of a fear and distrust of government. I'm going to suggest that's only part of the story. The real beauty of this clause is that it creates inspection and evaluation. And that will change behavior. The fact that the president cannot solely nominate and then have it confirmed, these individuals, creates this kind of duality where there's investigation. The ancient Roman philosopher Seneca said, if you sit in judgment, investigate. If you sit in supreme power, sit in command. So this is an opportunity for cooperative competence, an opportunity for mediation. It creates an adversary process with a resolution from more. And it also creates the opportunity for transparency. And notice I said opportunity. We're not maybe seeing these today with what the prior speakers have said, but at least it creates those opportunities. So in this way, I think it goes a lot further than just dividing it up because of a distrust of government. It really provides the essential framework, the deep structure of an adversarial process, which I think is really beneficial. So it's been challenged because ideology has been considered. And like Russ, I don't think that's a proper challenge. George Washington nominated John Rutledge as Chief Justice for the Supreme Court in 1795, and he was rejected. But the background to this story is what makes it interesting. That was the second nomination by Washington. He was confirmed, Rutledge was, in the first nomination. So you would think confirmed once, certainly confirmed twice. After being confirmed the first time, he resigned to become Chief Justice of his home state Supreme Court, South Carolina, and then was called by Washington to come back to the federal court. Except he made one big faux pas. He gave a speech against the Jay Treaty. And members of the Senate who were Federalists said, we don't like that at all, and that's why he wasn't confirmed the second time. Talk about blatant ideology. So we have that at the beginning of our country, and over the years, this has arisen. So I do not view the Bork confirmation proceedings as a watershed. I don't consider it out of the ordinary, and I don't even consider it a failure. He at least got to have a hearing. unlike many people, as we've already heard, who are kept in what I call the Twilight Zone, the languishing. But I do think historically there have been problems. So the problem historically, the major problem, has been deference. And there have been a lot of same-day confirmations. For example, William Howard Taft, our 27th president, became the 10th Chief Justice, replacing someone he had appointed. He was confirmed on the same day in secret proceedings because they were not opened up until 1929 by the Senate. So that kind of confirmation, I think, can be debilitating. And interestingly, we need to sometimes save presidents from their own appointments. One of my favorite quotes by Eisenhower is, "I made two mistakes. They're both sitting on the Supreme Court." So bottom line is, this kind of process that has a real robust debate actually can help the presidents themselves when they nominate someone. And let me also say about Obama. President Obama, as we heard, ranked last a lot of times in confirmation. But he's actually first when it comes to nominating women and minorities. And the confirmation for him of percentages of women and minorities much higher than the previous two presidents. So having this process where there's two groups often can be helpful. Let me talk a bit about the president and the political polarization. One of my favorite quotes from an oral argument in the Supreme Court is the Sebelius case, the Affordable Care Act. And Justice Kennedy is talking to counsel, and counsel says, yes, Congress wanted this to be severable. And Kennedy replied, are you talking about the real Congress or a hypothetical one? And everyone laughed. And the bottom line is, this has permeated all of government. So it's something that is pervasive and is not just in the appointments process, obviously, but it's everywhere. And it's already been pointed out, the slowness of the process, that it's twice as slow now as it was in the 1900s. But I think the inactivity, and this was pointed out earlier too, that nominations languish without a hearing because they're not required. And I'm not suggesting they should be. President George W. Bush said that Congress, Senate had a duty to have hearings. I don't agree with that. But you have nominees languish. So John Roberts was first nominated to the federal bench by George Herbert Walker Bush. A decade later, he was re-nominated, it just languished, again by George W. Bush. And it languished, and for the third nomination, 3 times is the charm, right? He was actually confirmed, a hearing was held and confirmed as Chief Justice. So that more than decade span, not necessarily saying it's always bad, but we really want to look at this twilight zone of inactivity. And of course, vacancies, and I think it's already been brought up and debated, it's not just the vacancy itself that may be bad, it's the impact. And I'm looking now at the impact on the administration of justice when you have, and I think the count now is about 45 federal judgeships that are vacant with 10 nominees for them, that there are senior judges to pick up the slack, but do we want to have these people who are dedicated to their jobs and not just coming back to fill in these gaps? What is this doing to the administration of justice? That needs to be examined further. I think actually today, the biggest area we can see that has been changed from history is the Senate's own procedural rules. The Senate acted largely by custom over time, and I think that was a problem. They had this idea of blue slipping, where the senators from the home state actually had essentially a veto over nominees. That was informal, although the chairs of the Judiciary Committee and even the presidents would have this senatorial courtesy. It's an extra layer. In some ways it can be good, but this kind of informality allows a lot of things to go on behind the curtain. I'm a big fan of getting the Wizard of Oz from behind the curtain, and let's have the confirmation hearing where they can actually talk to each other, even if it's staged. I think the Act of 2011, the Appointments Efficiency and Streamlining Act, was very helpful, but they also appointed a working group to look at the process more. So in the 1900s, they started opening up the process. In 1929, it went from closed session to open hearings. And only in 1955 did they start having the nominees actually testify. And of course, there has to be a hearing for that to occur. Now, one last thing I just want to talk about today, which I think has caused a fundamental shift in the entire process, and that's Twitter. And I'm not talking about Twitter in particular, I'm talking about the advanced technology revolution and micro-broadcasting. Every word that's said by a nominee, so it's not just finances, I think every word that's ever recorded down the line is going to be brought back. See Justice Sotomayor and comments that are made decades earlier. This is not necessarily a bad thing. I like freedom of speech, and I think that is useful. But confirmation hearings, particularly ones before the Supreme Court, have gone from local theater to Supreme Court halftime shows. So I find it very interesting when in 1995, an assistant professor from the University of Chicago wrote that these hearings involving Justice Ginsburg and Justice Breyer, she basically said, yeah, they stonewalled the Judiciary Committee very effectively with non-answer answers. Who wrote this article? Elena Kagan, who used that very script when she was nominated. So while I love these hearings, I don't know if they've been as effective as they could be. So, having said all this, I think there is an implied presumption over history of confirmation, and that too much deference is bad, just like too much obstruction, as people are arguing today, is bad. And I think the Senate, with its rules and having hard and fast rules and not just custom, will be the way to hopefully create a better process in the future. And why am I hopeful? Because I'm a Mets fan. Thank you very much.
Thank you, Professor Friedland. At this point, we're actually running a bit ahead of schedule. We don't have anything to fill the gap in the interim, so I think what we're going to do is break a little bit early for lunch, and here's how that's going to work out. We're going to have sandwiches set outside in a couple minutes for everybody, just outside this room. For any of the participants who are from out of town, the moderators, faculty, feel free to head over to the Birdman Lounge, which is room 3000. We have some private space for you. We know a lot of people have been staring at you all morning, and you may want to go into hiding for a bit, so that space is for you. For DLJ members, other folks who don't want to be in room 3000, please feel free to stick around here again. We'll convene for the second half of this panel at 1:30 p.m., so if everyone could be back here on time, maybe we can get started a little bit early and pick up there. Thank you.